Good afternoon, everybody. Thanks for joining us. This is phase 2 of the country's dealing with COVID. The CARES Act, which we all struggled through last year, starting in the spring, and waited actually until December 27th when Congress enacted the new Consolidated Appropriations Act and the Response Relief Supplemental Appropriations Bill, left many items open, some of them very significant, and they've been resolved in the borrower's favor, which we'll go over. We're going to be learning a lot about the deductibility of expenses and the fact that they're non-taxable. Confusion by the IRS has been cleared up. The regs are going to be a moving target. Obviously, they haven't been issued. One actually came out today, about 45 minutes ago, which we're going to try to incorporate. With respect to jumping in the new loan program, as of tomorrow, lenders with less than $1 billion in assets will be opening up their portals. So if you're with a lender that's a small lender and they have $1 billion or less of assets, you may be able to jump on to start making the application process for PPP2. On the 19th, this coming Tuesday, all other banks will be opening up their portals for processing of loan applications. So keep those dates and times in mind. At this time, I'm going to turn it over to start the first part. Colin, you're up.
Thank you. So we're talking about the Consolidated Appropriations Act and Coronavirus Response and Relief Supplemental Appropriations Act of 2021, which is obviously a very succinct and easy to recall piece of legislation naming. What is it? It's a $2.3 trillion spending bill that combines $900 billion in stimulus relief for the COVID-19 pandemic with $1.4 trillion of spending for the 2021 fiscal year. It was passed by the House and the Senate on December 21 and then signed into law on December 27, 2020. It is, in fact, the longest bill ever passed by Congress, which I guess is a fun fact. Unlike the CARES Act, which was actually a fairly succinct piece of legislation, this was integrated into a much larger bill, and thus, it's a slightly different posture. So, this slide basically illustrates the allocation in the bill. It is $325 billion for small businesses, $166 billion for $600 stimulus checks, $120 billion for extension of increased federal unemployment benefits, and on and on and on. This is a major bill with major ramifications for the economy going forward. This is real relief for businesses, and very good news going forward for American business owners. Paycheck Protection Program Round 2. For those of you who were part of the last series of PPP seminars we've been on, we've talked a lot about the PPP programs. Round 2 came about through this legislation. There's $325 billion of new money for new loans or second draw loans with some set asides. There's $15 billion across first and second draw PPP loans for lending by community financial institutions. There's $15 billion across first and second draw PPP loans for lending by insured depository institutions, credit unions, and farm credit system institutions with consolidated assets of less than $10 billion. $35 billion for new first draw PPP borrowers, and $15 billion and $25 billion for first and second draw PPP loans, respectively, for borrowers with a maximum of 10 employees or for loans of less than $250,000 to borrowers in low or moderate income neighborhoods. There's been some more targeting in terms of this revised bill than the original bill, which came about very quickly and was very general in its approach. Who's eligible for this Paycheck Protection Program round 2? You must be a small business. This bill changes the definition of small business from the original eligibility requirement of 500 employees or less and to no more than 300 employees. This is with regard to second draw loans. I will note that the first draw loan eligibility is still 500 employees or less. For those looking for a second draw loan, you must have used up your first PPP loan. This is a minimum requirement for applying for a second draw. And you have to have spent the loan on qualified expenses. You also have to show a loss of 25% quarterly revenue. How do you show this? You have to show that revenues dropped 25% during one of the quarters of 2020 as compared to 2019. And forgiven first round PPP loans are not considered in the gross receipts, but all other revenue will be considered in determining your eligibility. The type of organizations now added are, in addition to all of the previous eligible institutions, you've got tax exempt organizations with no more than 300 employees and for whom lobbying activities are not their primary engagement. You have destination marketing organizations, housing cooperatives, broadcast stations, newspapers, and public broadcasting. It's good for people to understand that as part of this expansion of the original PPP program, if your original PPP calculation has increased due to the change in the SBA's interim final rules or a calculation error in the original application, you can actually ask for an increase in your first loan if and only if you have not received forgiveness already. So this is a chance for those people who have not gotten forgiveness. If for some reason the rules changed, and we all know that the rules changed as the loan program went on, to readdress your original loan if you've not yet received forgiveness. If you haven't, if you didn't apply originally or are newly qualified to utilize the program, then you can get a first round loan and potentially a second round loan as well. The portal has opened on January 11, 2020 to first draw loans. And then on January 13, 2021, January 13, 2021 for second draw loans. This has been a moving target, and the SBA just released further update just this morning saying that they're going to reopen the Paycheck Protection Program loan to all eligible lenders. Originally, the thought was that it was only going to be to community lending organizations. Now they've announced that all lenders with 1 billion or less in assets will be able to open up their portals to first and second draw applications as of Friday, January 15, that's tomorrow, and that the portal will open on Tuesday, January 9, 2021 to all participating PPP lenders for first and second draw loan applications. So, and as a crucial reminder, all new loans, the deadline is March 31, 2021 for applications. So do mark that on your calendar and do, I would speak with your lender and figure out if they've already opened their portal because they're considered a community financial lender. And if they have, obviously, the sooner you can get your application in, the better. And if otherwise, I would be ready for the new portal opening dates, which are soon arriving. So who's not eligible? Publicly traded businesses, entities primarily engaged in political lobbying. This is a new twist. entities created or organized under the laws of the People's Republic of China or Special Administrative Region of Hong Kong that hold directly or indirectly 20% of the interest in a business, or that retain as a member of the entity's board of directors a Chinese resident. This is also a new eligibility standard. Also ineligible are people who are required to submit a registration statement under the Foreign Agents Registration Act, entities that were not in operation on February 15, 2020, businesses that received a grant under the Economic Aid to Hard-Hit Small Businesses and Nonprofits and Venues Act, which is also new legislation. And those businesses defined in 120.110 of Title 13 CFR, which are cannabis companies, lenders, illegal gambling organizations, live performances of a prurient sexual nature. So there have been some carve-outs here that are new. In addressing loan amount calculation, qualified businesses may receive up to 2.5 times the average monthly payroll costs in 2019 or the 12 months before the loan application, capped at $2 million. So this is a departure from the $10 million cap in the prior round of PPP funding. Seasonal businesses are going to be able to use any 12-week period from January 15, 2019 to February 15, 2020. The maximum loan amounts for the hospitality industry are also important to understand. Those who are in the hospitality industry, your lobbying forces have done a great job. Second draw hospitality industry borrowers are going to be able to use a 3.5 times multiplier of their average monthly payroll costs to calculate the maximum loan amount, subject to a $2 million cap. This is, obviously in recognition of the fact that this group has been some of the hardest hit of all of the industries affected by this pandemic. For the covered period, borrowers are now able to choose the length of their covered period, so long as it's at least 8 weeks and it's not longer than 24 weeks. So this will allow the borrowers a little bit more control over how to utilize their PPP loans. And either period will begin on the date the funds are received, just as it did in the prior PPP loan. Also, the interim final rules that have been issued contain provisions that allow a recipient to request an increased amount on their first PPP loan if they've not already applied for forgiveness, as I mentioned before. So just to recap, the initial PPP loan had the factor which was introduced well after the original legislation was passed, requiring that 60% of the funds be used for payroll-related expenses in the relevant covered period. That remains. And, but however, on this round, for second round loans, existing payroll expenses have been expanded to include group life insurance, disability insurance, dental and vision benefits. It's also been clarified they'll not cover payroll expenses for wages used to obtain the employee retention credit, which is something that you'll hear about shortly from Mr. Towne. Also, an issue that was raised many times over the last several months, and something that appears clear from the present guidance, is that for sole proprietorships, partnerships, or S corps, can the owners get paid during this period? And the answer appears to be yes. The Form 3508 indicates has an express place in, and that form clarification is the forgiveness application. That form has a place specifically to factor in payments made to the owner of the business. In addition to the existing to the expansion on payroll expenses, there have been expansions to the non-payroll expenses that can be paid from the loan and submitted for forgiveness. So in addition to the prior non-payroll expenses under the PPP. Now you can make payments for software or cloud computing services that facilitate business operations, product or service delivery, the processing, payment, or tracking of payroll expenses, human resources, sales or billing functions, or accounting or tracking of supplies, inventory, records, and expenses. Covered property damage, costs related to property damage and vandalism or looting due to public disturbances in 2020 that were not covered by insurance or other compensation. Covered supplier costs, expenses incurred by a borrower under a contract or order in effect before the PPP loan proceeds were dispersed for the supply of goods that are essential to the borrower's business operations, and covered worker protection equipment, PPE. That is something that businesses have become intimately familiar with, the need for PPE. You can now count the costs of personal protective equipment incurred by a borrower to comply with rules or guidance issued by the Department of Health and Human Services, the Occupational Safety and Health Administration, OSHA, or the CDC, or state or local government. So that's starting, that goes back to March 21, 2020 to the end of the National Emergency Declaration. And as noted below, the previous non-payroll costs are still available. As Jim alluded to in his opening, the bill, this bill crucially confirms that business expenses, which would normally be deductible for federal income tax purposes and paid out of a PPP loan, may be deducted still. That this is something that the IRS, well after the original loans were applied for, made a tax ruling basically saying that because the PPP loans were not taxed originally, that they were going to be then not tax deductible. This was a major win for businesses to have this provision now clarifying very clearly that these remain tax deductible regardless of whether they've been paid out of PPP funds or not. And importantly, the date of this provision applies to tax years ending after the date of the enactment of the CARES Act. So if you've already filed a tax return without deducting PPP eligible deductions, you should consider amending your returns to claim the expenses. Hopefully that hasn't been the case, but for anyone that is in that boat, you should take a look at that and consult with your accountant. On to Chrissy Taylor is going to take you on and talk about loan forgiveness.
All right. So loan forgiveness, that is the, that is the fun part of all of this. That is the part and the reason that you want this loan. So not a ton has changed from, as Colin had talked about, the kind of things that you can use a loan for. But what has changed, and has changed multiple times, is how you apply for that forgiveness. Now, what they're hoping is that with this whole new bill that they pass, that they've kind of clarified some things. So you still, and as they were kind of talking towards the end of the first PPP loan, have 10 months from the end of your covered period to apply for forgiveness. So if you chose that 8 weeks, at the end of those 8 weeks, you have 10 months from that day to apply for forgiveness. If you chose 24 weeks, you have 10 months from the end of that 24-week period to apply for forgiveness. 60% of the loan proceeds have to be used on payroll costs to get full loan forgiveness. Now, that doesn't mean that you can't get a partial loan forgiveness. You definitely still can get some forgiveness, but if you want that entire thing to be considered free money, then you need to make sure that you've used at least 60% on those payroll costs. And that's not just wages, as Colin said, it's all those other things that you can revisit in these slides, but do make sure that you spend at least 60% of the proceeds that you got on those payroll expenses if you want the entire loan to be forgiven. Currently, there were 3 forms that they put out. They all start with 3508, and they have kind of different parameters to them. So there's a 3508, the 3508EZ, or the 3508S. I'll talk a little bit more about them later, but basically 3508S, that's the easiest, shortest form. 3508EZ, that's a bit more work, and 3508 is the most complicated, needs some more math from you. One of the new things that they mentioned in the bill was that there was going to be kind of a streamlined forgiveness for people who had loans of 150K or less. So if you got one of those smaller loans, your application, they say, is going to be like a one-sheeter, and it's going to be really easy. You're just going to have to make some certifications. There aren't going to be a lot of calculations, and it's something that should kind of streamline the process for those smaller loans. Rightly or wrongly, they assume people who got smaller loans perhaps are less likely to have had some kind of fraud or something inappropriate, so they're not requiring as much from them. We haven't seen that new one-pager yet for those loans. The SBA has till, I believe, the 21st to get that new one out, that new application, based on the 24 days from bill passage. So we will see what that will be. I'm sure it will go up on the SBA website. We'll update our news section to include that form and send around an email when we get it. But right now, we don't know what that looks like, but it should be something easier. All of those forms, so every one of those ones we went through that currently exist, all require some of the same basic information, such as the legal name of your business, the business address. If you're operating under a DBA or trade name, kind of depending on the state you're in, you might call it something different. The EIN, that federal tax ID number, your phone number, general contact information, the SBA loan number, the lender loan number that you got from your particular bank, the actual loan amount. So before you even pick the form, you should know some of these information. The disbursement date, so the date you actually got those loan proceeds, the number of employees, so that calculation you made for full-time employees when we kind of talked about this. If you don't know what we're talking about, I highly suggest you look at one of our old videos from the spring, but that calculation of full-time employees at the time of the loan application, and then the calculation of employees you had at the end of that application period. After you spent all that money, how many employees did you end up with? And the reason that's important is that this is the whole purpose of this bill, both the one that was, at the beginning of last year and this one. The whole purpose was to keep people employed. So they care a lot about those numbers and the wages you paid those employees. So it was all about keeping people employed. So that's why those are on every form, because they want to make sure that you use those loan proceeds to keep people employed. If you got an economic injury and disaster loan advance, that grant, that at the time last year was between kind of 1 and 10K, and they gave it to you based on the employees you have. If you got that, or you get the new one, which is just a flat 10K, you need to put that on here as well, because they want to know. It won't hurt you from a forgiveness period, but it might hurt you up front in newly applying for one, because they kind of calculate that in your amount. But generally, you just need to have that information. There was a provision in the previous one where it talked about how you could use a PPP loan to refinance an EIDL loan. And if you did that, that's also important to have all that information, because they're going to need that in the application as well. And then by forgiveness amount, when you did your calculation, if it wasn't a full forgiveness, say you got 100K and you think you spent all the money right and you're going to get 100K, that's really easy. But if when you did your calculation, your numbers were off, or you didn't use it, the 60% on payroll costs like you were supposed to, then your forgiveness amount might not be exactly what you got. And that's kind of where you'll have to put that information. So a little more about these forms. The 3508S, those are for people who had a loan amount less than 50K at the time, which seems interesting since we're getting that new one pager. I'm not sure this form's really going to be used very much, I guess, unless there's some kind of certification on that one page form that isn't something you could certify to. So if there's a difference that isn't just the loan amount, that might be the scenario where this form still comes up. I'm not sure because we don't have the new form yet, but that's my hypothesis. You're not required to show any calculations on this form except or monetary amounts except the forgiveness amount we talked about. They are still going to require documentation. So kind of the stuff you got together when you figured out how much money you were supposed to be given is still the kind of things they're going to need at the end. So that could be bank statements, tax forms showing, money that went to certain people and certain things, canceled checks for the payment of things. If it's a non-payroll expense, then maybe you need a copy of the lease agreement showing how much that lease was, or the mortgage showing what those mortgage interest payments were going to be and when they went into effect to make sure they were in that right time period. As a added extra, if you haven't, and it's something we've seen in some people's forgiveness applications from the first round, both banks and the SBA are requiring kind of corporate meeting minutes or resolutions authorizing the company that's yours to borrow this money. So if you haven't already made those minutes or that resolution or had your attorney do that for you, that's something to flag for you, because we've had to make quite a couple of those for our clients. So that is something that banks and the SBA are asking for. So make sure you have that. Side note, generally a good practice to have all of that memorialized in writing just in an average year. So definitely have it for this because they are looking for that. Typically, if you get any kind of loan, traditionally, that's kind of something that banks will ask for. So it's the same type of thing. They just definitely want it now for this loan. The 3508 EZ is for people who are self-employed and had no employees, or they did not reduce the number of employees or the wage by 25%. So what that means is if you kept everybody exactly equal to the numbers before, so when you did that calculation, you have the same number of employees and you didn't cut anybody's wages down below 25%, then you're good to use this form because you had no substantial changes. You use the proceeds for what you were supposed to, which was retaining those employees and keeping their salaries up. So all of that was really important and you did that. So you get to use an easier form as your present for doing what they wanted you to do. Just to reiterate something, again, we talked about the first time around, there is a cap on those wages up to 100K. If you reduce an employee whose wages were more than 100K to 100K, that does not count as a reduction of more than 25% because that is the max amount you can use to pay. It's that 100K annualized and broken down into that covered time period you picked. So that wouldn't be considered a reduction if someone had 150K salary and you bumped them down annualized to 100K. That's okay. That wouldn't be something you'd be penalized for. If you don't meet the qualifications for those previous two forms, then you're stuck with the longer one, which is the shorter form name, but the longer form. So it's just the 3508. It's 5 pages. That's because it includes a calculation form where you have to make a bunch of those mathematical calculations to show the percentage that you were off on this, or this, being the employees, the wages, reductions. You kind of have to do all of that math for that. So if you don't like math, then I'd spend your money on what they want you to, because then you can avoid doing a lot of math in these forms. They're still going to look for all of the forms that you need for all of those, but this one also wants documentation supporting the calculations you made about full-time employees. So if you were like, I had a reduction in one full-time employee, they want to know how you got there and show them that you had 8 employees and now you have 7. So be able to show that. And as I said, there's going to be a new simplified form for loans under 150K. It will have just a little description that you did everything that you were supposed to. You're going to certify to all of those things. At least this is what it's supposed to say. And then give them the relevant relevant stuff that they ask for, and then they'll just kind of, send you on your way. Now, generally, although the SBA isn't asking for documentation for that form, and they might still, as we know, they change their mind a lot, your lender can still ask for information. So even if the SBA says, no, you don't need all those things those other forms did, your lender can still turn around and say that they need those tax forms or those payroll forms or those canceled checks. So do still have those documents no matter what form you use. It's better safe than sorry to know where they all are and have kept records of how you kind of spent all that money. Since we originally publicized that we were doing this, luckily 2 interim final rules came out from the SBA. They're available in their very long forms on the SBA website. Rule 1, I believe, is 42 pages. Rule 2 is 82 pages. So they're quite long and they have lots of information in it. But I wanted to pull some of the things that I think are most important. So if for some reason you wanted to go back and look at them yourselves, again, we'll provide those links, but this would enable you to kind of know the information that's in there. So for example, it talks about who is newly eligible for a first draw PPP loan. So as Colin said, that got expanded. That's contained in these rules. The affiliation rules, they kind of clarified that. So if you're someone who owns multiple companies or has one company that then owns multiple companies, they spend a lot of time discussing how that determines each of their sizes and if you're considered bigger or smaller, depending on, do they aggregate all those employees because you're affiliated, or do they separate them out? If that is a question for you, this would be where more of that information is. It is very similar to kind of where we left it off in the first round and where we were last year with affiliation, but they did kind of clarify it and say how that works specifically. They clarified and confirmed that self-employed individuals may apply for a loan. A seasonal business, it's similar to what they said previously, just the time period kind of changed, that you can pick those 12-week periods between February 15th, 2019 and February 15th, 2020. That's especially important for hospitality seasonal businesses, as I know that certain parts of your season have, are busier, so you perhaps had more employees. So I'd be very careful with like the periods that you pick, because depending on what your full-time employee numbers are, like say you hire more in the heat of the summer season, but you have less, on the tail ends, if there's some way you can skew it a little bit to pick up a lower employee number to help yourself out, I would sure pick the 12-week period that helps you out the best. I'm not sure this applies to any of you, but if any of you own a legal gambling institution, they are allowed to apply for the PPP loan. That's a new one. Colin went into the ineligibility, so I won't bore you with that. But if you want, if for some reason you're worried you're ineligible, they have all of that information written in a very long form that you can see who's newly ineligible.
Chrissy, could I just say something?
Yes.
My understanding is a seasonal business is capped at 7 months a year. That a seasonal business by definition is a business that's open no more than 7 months a year.
Yeah, I would agree. Yes, by how it would. Yes.
I know several of the hospitality people are in parts of the country where they may be able to be open 12 months a year, and some in the Northeast may be open 4 months a year. So I wanted to make that clear.
That's true. So yes, a seasonal business could be a little different depending on where you're located in the United States, but generally you need to be open that 7 months or less, because if not, then you very obviously are getting closer to a full-time, 12-month a year business. So they do need to have that differential. So that let's see, back to the first interim rule. As I said, it had the affiliation rules. There was additional information. They actually provide examples of calculations. So if you're having trouble figuring out how you would calculate the money you're supposed to get, they have a couple examples, like if you had this many employees and this whatever, and their wages equaled this, and they go through that. They even have some examples where if you had gotten that EIDL grant, they show you how you kind of factor that into your loan calculation as well. Can a single corporate group receive unlimited PPP loans? The answer pretty obviously is no. There's only so much money out there. So the reason they rolled this out slowly into certain lenders and to certain people is because they're trying to give, the smaller mom and pops and people who didn't have access to money the first time, access to the money first. There's only so much out there. So they have put this cap that no single corporate group can get more than 20 million. That sounds like a really big number for a lot of us. So probably not applicable, but just generally the theme of the SBA's reasoning and the government's reasoning and how everything was rolled out is to put these underprivileged, smaller businesses to the forefront and have the bigger corporate ones be towards the end. So if they run out of money, they run out of money for the big guys, not the little guys. That's kind of the theme of how they rolled out this loan this time around. Independent contractors, when this all first started, it was unclear whether or not they'd count as an employee for you. They do not. This is expressly clear in the interim final rule. They say that the independent contractor is not an employee of you because they could apply for this loan by themselves. So there is no way you can count them in your numbers for better or worse. So you can't get a bigger loan because you counted them as part of your numbers, and you can't be penalized if you had less independent contractors. You utilize less of them this year. They don't count as employees. So do keep that in mind. If you have a student worker, they generally count as an employee, no problem there if they're an intern, as long as you're not some kind of education thing, work study related thing. But if you had a student come work for you as a summer, as an internship, they would count as an employee in your employee numbers. So that would work out for you. Again, they clarified that you have to pay the loan back if you don't submit your forgiveness application within that 10-month period. So for some reason, you don't want this free money and you don't submit in those 10 months, month 10, you have to be ready to start making payments on this loan like a regular loan. So do make sure that you apply for forgiveness and you're calculating that 10 months from the end of your covered period, because you don't want to miss that. If for some reason, and I doubt it, because if you're here, that means you listened to us and you did everything correctly. But if for some reason you used your proceeds incorrectly and your current forgiveness application is flagged, they're not going to let you apply for a second one. You can start the paperwork, but the SBA is going to be like, nope, this particular person, bounce it back. We're still investigating what happened to them the first time. So if you're someone who hasn't applied for forgiveness, do a good job not to flag your application if you're hoping to go for the second loan. So just keep that in mind, that you can't get the second loan until they're cool with the way you handled your first one. The second rule is specifically about the second draw. So all of that stuff kind of is the first and, kind of morphs into part of the second, but the second rule is specifically kind of about the second draw loan. So it talks a bit about the single corporate group again. So this time, if you're getting a second draw loan, a single corporate group can't receive more than 4 million. So they cut that way down. There's the cap of 2 million for everybody on these loans versus the 10 million for the first one. It's 2.5 unless you're hospitality, and it's 3.5. So it kind of clarifies that. The documentation required for those with an amount greater than 150, they have to show that they experienced that 25% reduction that we were talking about. That information is in this second rule. They want to calculate the gross receipts of all your affiliates. So again, if you're someone who has multiple companies yourself, or one company that owns multiple companies, please be very careful with those affiliation rules, because they're going to look at all of those different things when they calculate how much money you're entitled to, what your cap is, all of that kind of stuff. How to submit this application, that's the most important part. As Colin said, for lenders that have assets less than 1 billion, it opens tomorrow. If not, it opens for all lenders on Tuesday. You can either use the SBA form, which they have on the website that you can take a look at, or your lender might have a slightly different form or an online portal or something like that. I assume that it's likely going to be very similar to whatever you did the first time around. They're probably just going to put in provisions, your lender that is, to ask about that 25% reduction in a quarter. So do just kind of keep that piece in mind. Forgiveness is tax-free. They have absolutely confirmed that. So that's great news. And that is super great because that would be problematic for some people. That was a lot of extra money you got this year and you don't want to be hit with it on the backside. However, with the one caveat that although it is federally tax-free, there is some rumbling in the states. So some states like California and North Carolina have already announced that they will not follow the federal tax-free treatment. So they are going to tax people on this loan in those states. So we should keep an eye out. I'm hopeful that the Northeast perhaps won't join that bandwagon, but do keep that in mind that although it's federally tax-free, some states are not considering it tax-free. So I flagged that for you to keep that on your radar, just so you know that could be a problem. If that would be a problem for you, it probably doesn't outweigh the benefit of taking the loan, but it is just something that you should have knowledge of before you choose to take the loan. And then the other great news is if you got one of those EIDL grants, it doesn't reduce the forgiveness anymore. That was that 1 through 10K per employee. It's not going to be subtracted from the total forgiveness in that event. So that's great news, because I know in the very beginning, people were kind of applying for both because they didn't know how long it would take to get the PPP, and the EIDL was really quick and had a shorter form. So a lot of people got a grant up front. That's not going to harm you anymore. So that's really good news. Although the PPP is kind of the star of all of this, there is more about the EIDL. They did allocate additional money to the EIDL. So if you're someone that, you know, the first time around found out that the EIDL worked out better for you, whether it had to do with number of employees you had and that it would have been a really small number and it would have been more for the EIDL, there's more money there too. So if that was something that better suited you, you can still apply for that one instead. So that's good news. That grant now, they're not basing it off of number of employees. It's a flat 10K. So I know some people thought it was going to be 10K. And then when they reported they had 1 or 2 employees, they were upset to find they only got, you know, that 1,000 or 2,000. Now it's 10,000. If you are someone who was disappointed the first time around with that low grant, the SBA will issue retroactive grants. So if you only got 1 or 2K, you can go back to them and they'll give you that full 10K, which is great news. More free money, I suppose, but do keep that in mind. That is super, super duper important. If you get the EIDL, that loan itself is not forgiven like the PPP, but it is a lower interest rate. Not as low as some interest rates out there, but for a commercial loan, it's 3.75, which is pretty great. The term loan is 30 years, and that is important. They still have their eligibility where there has to have been an economic loss. They define small business as less than 300 people. That applies to most people, so that's not generally hard, but that is something to keep in mind, that there is other money available for you out there. So that kind of concludes the forgiveness section and those SBA rules and a little bit about the EIDL. I would like to acknowledge that I see your questions coming in and we will answer them at the end. So please keep throwing them in that Q&A as they come up and we will definitely get to them. I would now like to pass on to James Towne so he can talk a little bit about some of the other things that came up in that bill.
Before I jump into this, I wanted to pass along, so I don't forget it. Chrissy was talking about the fact that states may not allow, they may want to tax the receipt of the money indirectly by not allowing you a deduction. As I understand it, there's chatter in Washington to try and tie any relief that the states receive by large grants from the federal government to deal with how COVID has addressed or damaged the state's ability to function. They're going to tie that to you've got to bring in compliance with the federal rule with respect to the fact that you can deduct the expenses. Otherwise, it's going to be a frustration on a state-by-state basis of what the federal government's trying to accomplish. So it's hoped that the states and the federal government will be able to work that out so that you are going to be able to treat at the state level the same way you do at the federal level and allowed to be able to deduct the expenses that were paid with the PPP money. So under the employment retention credit, this is a refundable tax credit equal to 50% initially of the up to $10,000 in qualified wages on an annual basis. Under the new law, the credit is increased from 50% to 70%, and they've moved the marker from $10,000 per year to $10,000 per quarter. It's a nice increase. There's a 100 employee threshold in determining what are qualified wages, and wages are based upon an increase of 500 or fewer employees. I don't think anybody's here from the government. There did clarify the fact that you can include group health insurance expenses as part of qualified wages, which of course they did in the loan itself. The Treasurer and the SBA are going to be issuing guidance along the payroll costs paid during the PPP covered period, and whether or not they are qualified as wages to the extent that such wages are not paid from the proceeds of a forgiven PPP loan. So that if you're not going to be able to include the wages that you're paying, you're not going to be able to include in your employment retention credit calculus the wages paid with forgiven money. So that's one of the things you're going to have to keep in mind to see whether or not you're going to be eligible and whether or not you want to take advantage of this program. Employers that receive PPP loans may qualify for the ERC with respect to wages that are not paid with the proceeds, as I indicated. Section 6033 of the Internal Revenue Code defines gross receipts for tax-exempt organizations as sources of all income during the accounting period without subtracting any costs or expenses. It's really unclear to me why they included the definition that by itself is confusing or doesn't give specific guidance, but that's what they're looking for. They'll want you to apply as a tax-exempt organization what your calculation is on your annual tax return under Section 6033. You can include, as I indicated before, healthcare expenses as qualified wages, even when no wages are paid to an employee. So if you have somebody that you're continuing those benefits for whatever reason, by contract or whatever, you get to include the expenses of healthcare. The Families First Coronavirus Response Act, or FFCRA, gives tax credits through March 31st of 2021. In the initial PPP loan application, you were required to extend benefits to someone who's out on coronavirus leave. It's no longer mandatory that you provide that benefit. However, I think we can all assume that when the Biden administration comes in, that's one of the things they're going to probably kick back in place in order to try and create a softer cushion for employees. Nothing has changed in connection with New York state law and with respect to the leave that you're required to offer. If you have employees that ordered to be quarantined by local or state actual order, that is going to be mandatory for you to cover that employee. Otherwise, it's up to your discretion or whatever your personnel manual health insurance coverage provides. The employer has to provide, employers that provide FFCRA leave between January 1st and March 21st, you can take a tax credit for the amount of the leave. There are limitations on it. If it's an employee that you're providing these benefits for, it's maxed out at $511 per day or $5,110 for the covered period. If it's an individual who's taking care of somebody who's stricken with COVID, you're allowed to deduct and get a credit for $200 per day for the sick time with a maximum of $2,000 in the aggregate. And if it's your child or you're taking care of a child due to the fact that that child's school is closed, it's limited to $200 maximum per day and a $10,000 in the aggregate for each employee. There is a provision, obviously, that you can apply for the EFML exhaustion and get that $10,000 cap up to $12,000 for the period. You have to have actual quarantine with respect to an employee. There are a number of tax provisions that are dealt with under this new act, and most of them, I don't think anybody is going to look at some of these things. But with respect to the New Markets Tax Credit, MNTC, it's a great program that affords individuals and corporations the right to receive tax credits for making investments in equity investments in community development entities. And if you're in that circumstance, you're going to be able to pick up some tax benefits and credits moving forward through the new act. There's also the Work Opportunity Credit, tax credit. It's another federal program that affords tax credits for hiring certain individuals from targeted groups such as veterans, ex-felons, et cetera. It's maxed out at $9,600 per year, but it certainly is a benefit that the government's trying to push, especially with respect to rehiring veterans. You're entitled to recover a healthcare coverage tax credits of 72.5% of premiums. This applies to businesses that are paying for or required to pay for as a part of it, an arrangement with the PBGC for a failed retirement plan. I don't know anybody who's dealing with a carbon oxide sequestration credit, but there is the employer credit for family paid medical leave, which expired on 12/31. But again, the FFCRA allows a tax credit if you voluntarily reimburse employees for the cost of providing that leave through March 31st. For anybody who's been in the unfortunate circumstance of having to obtain a discharge of a mortgage due to your inability to pay, lost your home or whatever, it's your principal residence, they're excluding from gross income the amount of that discharged loan. There's an incentive for employers with respect to student loans. That's capped out at $5,250 per year. And that may be worthwhile looking at with your accountant if you have employees who are still repaying student loans, converting out a portion of their wages from taxable wages, assuming they were going to apply $5,250 or up to that amount annually against their student loans. Why wouldn't you get a credit for it? You'll avoid the tax as an employer. They'll avoid the tax, and they won't be paying for those student loans with after-tax dollars. It's a significant boost to your employees who are burdened by student loans. The payments, however, have to be made not to the employee in cash in the hopes that they'll pay them, but have to be paid pursuant to an existing educational assistance program that you'll need to look at. The income threshold for medical expenses, this cracks me up that that they're making permanent tax provisions that were scheduled to expire. I think we've all learned that permanent tax changes are about as permanent as the whims of Congress and the needs of the country for money. So assuming this is actually permanent, they've reduced the threshold from 10% to 7.5% in connection with your Schedule A filing. Under Section 179D of the Internal Revenue Code, there are any energy efficient credits that you can get, and they equal $1.80 per square foot for buildings that save at least 50% of the heating and cooling costs due to those energy savings applications or installations. That's worth looking at, certainly going forward. There's a gross income tax deduction provided, obviously, to volunteer firemen and emergency responders, which is nice. And let's see, a transition from a deduction for a qualified tuition and related expense to an increased income limitation for the lifetime earning credit. I don't think there's anybody on this call that's applicable to, nor the railroad track maintenance credit. Certain provisions and refunds and reduced rates are related to beer and wine distilled. That has to do with reducing the rates tax rates paid by craft brewers and distillers because they got clobbered, as did the restaurant industry for the same reason that people are not eating out and people are not drinking out, et cetera. So they were given a special tax rate to assist them. $15 billion has been dedicated for what's called the Shuttered Venue Operator Program. If any of you are operating movie theaters, live venue operations, et cetera, you have to have been in business on or before February 29th of 2020. You must be open or intend to reopen. You must have a reduction of 25% or more in the gross revenue related to the same quarter of 2019. Your loan is capped out at $10 million. And if you receive the Shuttered Venue Operator Program loan, you're precluded from receiving a PPP loan. And you see that when the tranches are made and distributions are made, when there's a first 14 days, you've experienced a 90% or greater decline in gross revenues. Second 14 days, you've experienced 70% or greater decline in revenue. And after 28 days, the grant awards is open up to all eligible participants. As of December 31st, 2022, the enhanced tax deduction for meals expenses are extended. They've extended the temporary deductibility of 100% of your meal expenses through December 31st of 2022. You remember that was probably 18 years ago when the hue and cry rode up about the 2 martini lunches, and the IRS and the government came up with regulations that said you can only deduct 50% of entertainment expenses, not entertainment, sorry, meal expenses. Entertainment expenses are still not deductible. However, to get the restaurant industry back on its feet, they're going to allow 100% deduction. So as soon as we're all eligible to avoid the ravages of COVID and we can go out and socialize again in restaurants, they want you going out and socializing, and they want you drinking craft beers to help those people along as well. There's a reduction of the adjusted gross income floor for medical expenses, which we talked about, back down to 7.5% from the 10%. There's going to be an increase, I think we're all expecting, of the cash distribution under the Cash Act from $600 to $2,000, hopefully. I think that's in the works. And one of the things that President-elect Biden has in his just announced last evening, $3 trillion Revitalization Act that he intends to hopefully push through Congress right after he's sworn in. Taxpayers, it's a nice provision that actually was one of the worst decisions, I think, when they simplified the Tax Act 4 years ago. They took away the ability of a lot of people to get a tax credit for small donations. And those of you who are working with charities probably noticed the same thing that I noticed with the charities that I've been involved with, and that is a significant reduction in the receipts of payments of $5, $10, $15, $25, $50, because people lost the ability to deduct those. So they're adding in a cash donation line of up to $300 for qualifying 501c3 organizations, which is nice. I often wondered why, when the Heart Association, the Lung Association have very powerful lobbies, how they were able to let this fall through the cracks 4 years ago to take away the ability for these small deductions and their deductibility, because it certainly has hurt charities. That's what I have to talk about.
All right. So
hang on just a second, if you could. One of the questions I have for Chrissy and Colin, I know there are a bunch of questions that are stacking up. One of the questions I have for Chrissy and Colin is a number of these regulations, as they're being promulgated, has to do with the forgiveness, whether or not you've received forgiveness. And my question is that forgiveness from your lender or forgiveness from your lender and the SBA? Because that's a two-part process under the original PPP loan. And I don't think it's answered, but I'd love to hear your input.
I agree with you that I don't think it's answered. But I would think if you've already started the forgiveness process with your lender and gotten lender forgiveness, going back on it would be hard to do. Chrissy, your thoughts?
So I would say that I feel similarly, I suppose. So from that perspective, I think that they haven't made it clear. I would assume that if you have the forgiveness from your lender, that you're likely okay. And I know that the SBA has been slow getting through those forgiveness applications. So there is a bit of that to worry about, but I think the timing will be okay and that you can apply. Frankly, I would say probably to apply and have them tell you no, that you have to wait, then wait yourself, just because we don't know. And kind of with everything with the SBA, given all the new fun stuff they had to do, it hasn't been exactly speedy when it comes to updating information or websites or any of that to kind of clarify those more intricate pieces.
I want to reiterate also something that Chrissy pointed out, and that is we've had a number of clients call up and ask for drafts of minutes approving by the corporation or the borrower the lending that took place last spring or summer, and those can be produced. Those documents under New York state law do not have to be executed contemporaneously with the actual meeting of the shareholders, owners, members, et cetera. So they clearly, you're going to date them today, but they are going to reflect the fact that on this prior date, there was a meeting of the minds and a meeting of the principals of the entity approving the business loan application. So keep that in mind. They're going to be asking for it because I've gotten, I think, 6 or 7 calls so far, people asking for those documents. So you might as well get in there quick and early.
All right, so I'm going to move over to our questions and kind of run through them. The general one, someone told us that they luckily have received forgiveness for both of their pieces. I know a lot of people, the bank upfront tells you that they have everything they need to forgive you, and then they boot it to the SBA. So that's kind of how that works for that piece. So I would just keep that in mind. It's not that they can't say that you're set without the SBA approval. It's just you really do want to know that the SBA is, kind of approved your loan. But again, I'm not sure it's going to stop you from applying for the second loan. So don't worry about that piece. Jim, is the ERC or Colin a refundable income tax credit or a credit against payroll taxes?
It's a refundable credit.
All right, so that was an easy one. The EIDL, I know some of you immediately went to go look to see if the ability to get that additional money. So if you had only gotten 1K first to get that, missing 9K, currently isn't on their website. That doesn't surprise me. Unfortunately, it took a while for them to start updating the PPP stuff. I imagine it's going to take them a while to update the EIDL stuff. So we're just going to have to keep refreshing the page. Frankly, this bill passed long before they released the interim rules. It took about, 3 weeks for them to update that status. Once this bill passed, the SBA website, if you went to the PPP part, said the PPP was closed, and they just updated that now. So unfortunately, it's probably not going to be a right of way. They're probably going to have to go back and update that website to kind of say how they're going to get people that money that they didn't get before. So don't be alarmed that it's not there, but don't be surprised that it's not there either. All right, let's see. I guess let's Jim, if employees were collecting unemployment due to a reduction in hours, can the business use the amount paid to those employees while they were collecting unemployment, or will the employee have to be off of unemployment? So I guess it sounds like, let's see, can a business use the amount paid to those employees while they were collecting unemployment? Does that make sense to you, Colin, perhaps?
Let me just.
Oh.
I thought what I understood the question, and I could be wrong, is if you're asking whether the money, so if someone has their hours reduced and they become eligible for partial unemployment due to the reduction in hours, they'll still be paid a limited sum by their employer. Is that limited sum continued to be paid payroll expenses? I would think the answer would be yes. And but any reduction would have to be factored in to determine whether or not your forgiveness would have to be reduced because you've reduced the person's pay more than 25%. So that goes back to the old reduction, forgiveness reduction requirements under the original PPP. So in short, I think, but of course, any sum that's unemployment is paid would not, I don't think you could claim that as a payroll expense.
All right. For the increase, the 3.5 times for hospitality industry, actually, if you haven't already applied for forgiveness, that looks like something that you might be able to ask for that increase on your first loan. So that if you haven't already applied for forgiveness, you might want to see if you can increase that first loan if you're someone that 3.5 multiplier applies to. That might be something you'd be able to do. I'm not really sure how they're handling the increases, unfortunately. I know for sure you can use that 3.5 to calculate what you'd get the second time around. I'm assuming that you can use that to increase your first time around if you haven't gotten forgiveness yet, but I'm still not quite sure how they're handling increases. As with everything, and as we said for the EIDL, I haven't seen some kind of form yet for increases. I imagine it's something that's going to have to trickle through, and the lenders are going to have to find out as well if you're someone who can newly increase the size of your loan. So I guess kind of touch base with your lender and see if they know how they're handling that. But I'd say for sure we can say that 3.5 is the multiplier you can use for your second loan. I think it's still a little wishy-washy how they're going to handle increases on the first loan, but I think that you'd be able to use that as a reason to request an increase. Let's see. Again, just about that EIDL grant, that 10K, it's not out there yet. I'm assuming you'll go to the SBA website. That's where you applied for the initial one. They haven't updated it yet, so I don't know. The EIDL is not a forgivable loan outside of the grant. So if you got that 1K, 2K, up to 10K previously, that was a grant. So you didn't have to pay that back. If you get the 10K grant now, it's a grant. You don't have to pay it back. If you get the difference between what you got the first time to 10K, that's a grant. You don't have to pay it back. If you get the EIDL, the loan piece of it, the economic injury and disaster loan, that is a loan and it's not forgivable like the PPP. So there are some people, like, it's not the same kind of free money as the PPP, but if you're someone who needed more money and you couldn't get it from your payroll calculations that you would have to use for the PPP, that's why some people went to the EIDL, even if they were going to have to pay it back, because it was better for them because they could get more of the money they needed to stay afloat. Let's see. The EIDL grant is a grant, so it's not forgiven. It's just free money when you get it. So if you got it, it's a grant and they're not asking you to pay it back. It's similar to when people get like kind of education grants is kind of how I compare it. So like when you went to college or your kid went to college, if they got a grant, they didn't have to do anything. They never came back to you for money. If it was a loan, then you had all that loan paperwork you had to do and you had to start paying back. So if you get a grant, there's nothing you have to do. It's free money. If it was a loan, that's where that kind of stuff is triggered to pay it back. You should try to get an increase for a second loan or for the first loan before you apply for the second loan. If you're someone who's eligible for an increase, for sure do that, because you forego your opportunity to do anything with your first loan once you apply for forgiveness. So if you haven't applied for forgiveness yet, and do make sure as a flag that you're still within that 10-month period, because you don't want to kind of jeopardize yourself with that covered period in the 10 months and you having to apply for forgiveness in that 10 months. Please make sure you're keeping track of those deadlines, because you don't want to kind of get stuck in that weird purgatory and end up with an issue applying for forgiveness because you're way past the 10 months of your covered period. So do keep in mind when your covered period was, because if you're dragging your feet on forgiveness and you're, at 9.5 months right now, you need to be really careful. So I would just flag that to be careful, because I wouldn't want you to lose complete forgiveness as you were debating whether or not you were getting an increase. Colin, if the proceeds were deposited prior to the change to 24 weeks, do we need to let the lender know if we chose the 24 weeks or the 8 weeks?
I think that's handled on the application for forgiveness,
Yeah.
As part of the forgiveness process.
That's my recollection for the form.
All right, so yes, I believe there's kind of some lines on those forms that clarify that for you. Those forms are available on the SBA website.
Right. Those are the forms that Chrissy was talking about in the middle of her presentation.
Jim, do you know if the EIDL grant is taxable?
No, it's not.
There you go.
Straight grant.
All right.
There's a question there, Chrissy, that's how is the lender going to forgive a loan without getting the green light assurances of reimbursement from the SBA? I think the answer to that is we're happy we're not lenders. But if they followed the rules, the presumption is that the loan granted was granted correctly, and that the forgiveness, if it's approved by the lender, is going to be accepted by the SBA. If there's a fraud that took place, It's a fraud both on the bank and on the SBA, and I suspect the bank is not going to have trouble and get stuck with a loan that it has to deal with respect to the SBA's money. That's my guesstimate.
All right.
In terms of the question about how detailed you have to be in order to certify to the lender on the second application that you didn't indeed use the first PPP loans on qualified expenses. If you've been forgiven, then that's in and of itself indicative that you used the loans appropriately. But in any event, I'm sure the lender will have will be addressing that on their own applications, and that, of course, every lender is just a little bit different on their applications. But I'm sure that'll be something handled during the application process for round 2.
There was a statement that jumped up and then was dropped off, but I'd like to answer it. I think I caught it before it dropped off. And that is, why would a lender forgive the loan unless it knows can they get forgiveness from the SBA? The process, as I understand it with the banks, are that the application for forgiveness is submitted to the lender, and the lender approves it based upon its understanding and its application of the rules from the SBA. So then you run into this curious situation of when do you take that forgiven loan off your books? I take the position that you take it off when the lender tells you it's forgiven, if you've received that notification. If the SBA then comes back and for some reason determines that it was not a forgivable loan, you'd obviously have to put that back on your books. But I don't think under those circumstances, unless there's gross negligence by the bank, that the SBA is going to charge back the bank with the obligation for that note. Otherwise, they'd be tying up the banks pretty severely. And the banks have very, very limited income that they've been deriving from these loans. I guarantee you from the bankers I talk to that the expense of administering these loans far exceeds the premium that the government's paying on these loans to the banks. So it certainly wouldn't be worthwhile for them to undertake the program if they're going to get tagged on little qualifications. So that's my 2 cents on that.
All right, so we're getting towards the end of the webinar. So I just want to say if there's any other questions, please chuck them in that Q&A so that we can answer them live. If there are any questions that come up when we are no longer on this webinar, we'll send this around, but here's the contact information for the 3 of us. You can email any of us, any questions that might come up as you navigate one, both, or any of the applications. I would also like to state that, technically there's going to be some more changes. There was a lot of changes the first time around. There's going to be some more changes this time around. It's kind of hard to time these webinars to make sure we give you as much information as we possibly can, while also, making sure it's timely so you don't miss the windows on things. So we will try to do a good job of continuing to update you. Those who attended in the spring know that we sent some follow-up emails as things changed. So we will be able to kind of keep you updated as we're updated. And do keep in mind the SBA is a bit slow. So what isn't there today might be there tomorrow. So that is something you will see, but you for sure can email us. Yes, we will have both, I believe, both the recording and the slides available. So you'll be able to refer to them. If they're not out today, they'll probably be out tomorrow. It takes a little bit for videos to render for us, but either way, you would definitely have access to this information, and feel free to email us. The initial email you got for this was from Kate, our marketing director. You can absolutely respond to her if you need to, and she can forward it to one of us to answer. I think I've seen some
Christy,
questions.
can I just jump in a couple things? That there's a repeat question that I meant to get to. I apologize. The question is, does expanded use of PPP proceeds, that would be under the current program, your expanded use, apply to the first round of PPP? In other words, one would adjust use of the PPP loan funds on the books before submitting forgiveness applications. My belief is the answer is no. These loan programs stand on their own. There's nothing in the act that I saw that is designed to allow you to readjust the expanded use of the PPP loan proceeds from loan as are instituted with respect to loan number 2 as against loan number 1. Have you anything different, Colin, Chrissy?
I don't.
They're not going back and it would be pandemonium. So I think the answer is no on that one. Somebody also sent in a question whether or not we'd be interested in doing a short program on the Main Street lending program. It certainly will if there's interest. It's a pretty straightforward program. It's a typical lending program run by the Federal Reserve. But if you'd like that, shoot a couple of emails to us. If we get some responses, we'll be glad to put up a short one. I don't think it'd be too long. We could even actually just record it and then notify you that it's up on the website if that's easier. Everything that today is going to be on the website. The video recording will be on there, and also the slides to help you. We're available at any time. Again, as Chrissy said, send us emails. If you have any questions, we'll try to answer them as best we can. But please do understand that although we hope that this program will be handled a lot more with a lot more strict regimen than the floundering around that the government had to do the last one program, the first program, there are going to be changes, and we're all going to have to be flexible about accepting those changes.
And I guess I'll give it one more minute just to make sure no one else has any additional questions, and then we will wrap this up. So I think, go ahead, Jim.
I'm sorry. I could type it here. The shuttered venue operated program is not available to hair salons. It is truly designed for open venues of entertainment. And I can't imagine that a self-employed hairstylist would fall within the parameters of that program.
No, it is in fact for kind of live entertainment venues and things of that nature. So movie theaters, concert venues, etc. It's more for those kind of things in particular, unfortunately.
Yeah. Though we do understand that California has taken some very, significant action with regard to, closing things down. As Chrissy said, it's focused on a different sort of shuttered venue.
I would say, though, if they're a self-employed hairstylist, the second round of PPP for eligibility, they did clarify that self-employed people could apply for the PPP loan. So you would be considered like every other self-employed person if you were a self-employed hairstylist. So yes, you'd have the same calculation issue perhaps, but that money would be available to you pursuant to those programs. Those are still open to you, even though the shuttered venue one is not.
The other thing I just want to, for all of us, we really appreciate the fact that you spent the time to join us this afternoon. We hope this has been beneficial. Looks like some people feel it has. We appreciate that very much. It's very important to us that you stay healthy and safe. These are tough times, and for the next 4 or 5 months until the vaccinations kick in, I think we've got to remain very vigilant. We want you to be safe and healthy and have a good 2021.